Morning, Your Honor.
Morning, Your Honor.
We're here on case number 12-1083A, State versus George Zimmerman. I have reviewed all the motions and I put them in an order that I thought that would be best for us to hear. Some of them may not be contested, so if you'll bear with me. The first one that I have is the state's motion to compel Shelley Zimmerman to testify at deposition.
Mr. Sims, on behalf of Ms. Zimmerman, is present.
Good morning.
Morning, Your Honor. How are you today?
I'm fine. How are you?
Okay for an old guy. State has a motion. We were, well, Bernie, you want to go ahead and give the outline there?
Sure. You might want to stand there.
Come on,
Okay.
wherever you want to be.
Thank you. Your Honor, I think the court's had an opportunity to read my motion. The bottom line is we had Ms. Shelley Zimmerman's deposition scheduled. We deposed her. She was subpoenaed. She showed up. She cooperated with Mr. Sims. I was taking her deposition for about 20 minutes. The defense, Mr. O'Mara, Mr. West, asked for a break. They stepped outside. They spoke to Mr. Sims. Mr. Sims came back in and stated that he no longer wanted to continue the deposition because and I think as explained in the motion, the bottom line is there was a debate as to whether she was listed as a witness by not by the defense. Our position was that she was listed as a witness. Regardless, we would subpoena her under our Chapter 27 subpoena power. So we would like to continue her deposition. I realize that under Mr. Sims', I guess, advice, she invoked the fifth at this time, and so we would like to continue her deposition. I think the law is quite clear that we are allowed to take her deposition. And our opinion is she was listed as a defense witness, and we would like to know certain things as expressed in the motion.
Mr. Sims?
Well, I think perhaps Mr. O'Mara has something to say with respect to whether or not she was listed as a defense witness and if she still is.
One, she was not, Your Honor. I think where the state got the suggestion that she was with a sort of generic statement on the bottom of our defense witness that said, we also, of course, retain the right to call anyone that the state has identified as a witness. And though she was not, I don't think, identified for the state, she may have been. I think that's where they sort of piggybacked onto the concept that she's now a defense witness. So let me be affirmative in that regard and say that we do not intend to call Shelley Zimmerman as a defense witness. They can address the Chapter 27 issues, but not for those purposes.
Thank you. Mr. De La Rondo, do you want to respond to that?
Well, Your Honor, they specifically, in their discovery, that is a defense, Mr. O'Mara, on behalf of Mr. Zimmerman, specifically listed all witnesses listed by the state. Ms. Shelley Zimmerman was listed by the state. I take that when they do their discovery, they say all witnesses listed by the state, that includes Shelley Zimmerman. I don't know that they can now say, oh, okay, we're not going to list it. I mean, are they going to go back and now not list certain people or retract certain people that they've already listed? So I think I'm allowed to rely on the listing of defense supplemental discovery, which they listed all witnesses listed by the state. If they do that, that includes all witnesses, which includes Shelley Zimmerman. She was listed as a witness by the state in the state's supplemental discovery on April the 10th of 2013. She has information germane to this case in that she was present when the defendant made statements not just to her. There's no husband-wife privilege. He made statements to other people where she was present and overheard it, and she is also germane to what happened right after the shooting itself. Our position is that she was listed as a witness by the defense. We're entitled to depose her. Now, if they're saying, that is, Mr. O'Mara on behalf of Mr. Zimmerman, that they're withdrawing her as a witness, we would still like to depose her under our Chapter 27, and we would be glad to pursue that in that matter.
I think that what the defense for Mr. Zimmerman has said is they have withdrawn her as a witness. I mean, they are. If they hadn't before, they are right now today. The thing that makes this unusual is that the self-same state attorneys that are prosecuting Mr. Zimmerman are prosecuting Mrs. Zimmerman. So now they have the opportunity to call her in, I guess, under an investigative subpoena and say, let's ask you some questions about this one case, although she has one that's not really connected, but loosely connected, I suppose, to George Zimmerman's case. So before I was going to let her testify, I wanted to make sure that I was going to get ordered by a judge, or she was going to get ordered by a judge, that she would have to testify when she has a pending case in this county with these same two fellows prosecuting her. Now they're asking her questions. just doesn't seem cricket. And because of that is why we ended the deposition, not because of anything that Mr. O'Meara or Mr. West had to say.
I think that the procedure is that she appears for the deposition, the state asks her questions. If she wants to assert her Fifth Amendment privilege, she does it per question. The state then certifies those questions and brings them before the court, and the court makes a determination as to whether or not they need to be answered. So that is the procedure that will be followed. The state's motion to compel the deposition of Shelly Zimmerman will be granted under those conditions.
Yes, ma'am.
Thank you, good to see you.
Thank you, good to see you too. May I be excused?
Yes, you may.
Thanks.
Your Honor, if I just may encourage the clerk, we do this each time that Mrs. Zimmerman is not here. It's a
Waiver of
Okay,
thank you very much. The next one is the state's motion in limine regarding opinion as to appropriate penalty or disregard of the law. Is there any objections to this motion?
No, Your Honor. Again, as I'm going to mention throughout all of these potential motions in limine, so I'll start with this one. I understand the case law, understand that commenting on punishment is not appropriate, unless, of course, somehow that door has been opened by the state or state witnesses. If it becomes relevant at that point, I would ask you to reconsider. But I'm pretty familiar with the case law that says I can't tell people that this is a life sentence or something like that.
Okay, so the state's motion in limine regarding opinion as to appropriate penalty or disregard of law will be granted. The next one is the state's motion in limine regarding prior criminal history. Any objection to that motion?
In a similar fashion, we're generally familiar that we can't solicit the fact that Mr. Zimmerman has no prior felony criminal record. Yes. Again, should the state open the door to something, we would certainly want to have the opportunity to offer whatever relevant evidence is appropriate in response.
So this will be granted without objection unless the state opens the door.
Your Honor, the state has made mention in the past through its discovery process and of, oh, I'm sorry, the court's rule will just be finished.
Okay, thank you. The next one is the state's motion in limine regarding calling of witnesses. Is there any objection to that motion?
Familiar with the case law, understand that I can't get up in closing and say, why didn't they call this person? Very familiar with that case law. I want to make sure that we are all familiar with the case law, however, that says that the state's failure to call witnesses, and if I decide to call them, then I can certainly say in closing, I presented to you these law enforcement officers or these retreat view witnesses or whoever it might be. If I decide to call them, I can certainly mention to the jury in closing that it was the defense who presented that. So case law is pretty clear. It is not quite as clear as the state suggests in their opening paragraph, but if you actually read the cases that the state cites, what I just mentioned to you is within that case law, and I'm clear with it.
And the case law is that when a witness is equally available to both parties, no inference should be drawn or comments made on the failure of either party to call the witness. The defendant may comment on the failure to call witnesses in its case in chief as an accusation of tailoring the testimony if the defendant calls those witnesses in his case. So we're all familiar with the case law. This motion will be granted within the parameters of the case law. And these may be getting that there will be some objections, but we'll go forward with them. State's motion in limine regarding the CVSA testing.
Same request, Your Honor. I understand that similar to polygraphs, CVSAs, and the evidence that my client took one at SPD and passed it would not be initially admissible, but again, and we're going to get to this, I think, as we get more into the substantive motions in limine, I think we're going to probably request or suggest an instruction from the court regarding how we attend to all these potential matters as we begin the case in opening and whatnot. I don't think that I can proactively present the passing of the CVSA. However, if somehow in some way Mr. Zimmerman's credibility is brought in issue, then I would suggest that that may be an avenue of inquiry that we would then be allowed to get into. So again, understand the case law, but it's going to really be dynamic decisions by the court when the evidence is actually presented.
Okay, Mr. Guy?
Judge, I don't believe that evidence would ever be admissible, but as long as we have the understanding that it won't be mentioned until and unless the court allows it, that's what we would ask.
Okay, the motion in limine will be granted unless there's a different ruling by the court during the course of the trial after a proffering of testimony or some motion. However, none of these motions in limine, the subject matter of which will be mentioned during opening arguments by either party. Then there's a motion in limine regarding self-serving hearsay statements of the defendant. Isn't this really the kind of a motion that the court would deal with by way of an objection during the trial? And you can't really identify every possible hearsay statement, whether it be from the defendant, about the defendant, or any other witness.
Yeah, yes, Your Honor. We were trying to anticipate, just in general, the understanding, the case law is quite clear in terms of our position.
I think that's the general approach we should take, although the state's motion has a very broad position, and that is that the hearsay statements would not be admissible, nor are there any res gestae type statements that would be admissible. As the court's well aware, there are recognized exceptions to hearsay or res gestae. So I agree we don't need to deal with that today, but we don't concede that there are no res gestae statements that would otherwise be admissible, even if there turn out to be other hearsay statements that would be.
Okay, my ruling will be that the motion is granted for the purposes that no mention of that will be made by either side during the opening statements, and the court will take up any hearsay objections during the course of the trial.
A moment,
We have
Your Honor.
Understand the court's ruling, and that should there be something more specific that we would ask the court to address, we will raise that separately.
Okay, thank you very much. The next one is the state's motion in limine regarding Trayvon Martin. Who wants to argue this for the state?
Your Honor, perhaps it would be easier to take this paragraph by paragraph. In A, the state is seeking to prohibit the defense from making any reference to the fact that Trayvon Martin had at any time been suspended from school. We would cite to the Johnson case, the 718 Southern 2nd 848 5th DCA 1998. And I do have an additional case for the court. You know, if I could approach with that.
Yes, please.
It is very short, but it is on point regarding actual school suspensions not being admissible because they are not probative of any material fact, and there is a danger, of course, for unfair prejudice. The cite on that is 57 Southern 3rd 228. It's a 4th DCA case from 2011, Coupas v. State, CUPAS.
I'm sorry, Mr. Guy, did you say that we're going to go through them paragraph by paragraph and my response, or you will just go through all of yours?
Well, I think we'll just take them one at a time, if that's what the court wants to do.
My response then?
Yeah, your response
Okay,
to
sorry.
the suspension from school.
I think, and this again just goes right into the same suggestion, I don't think that it is admissible preemptively. I don't think that I can get up in my opening and say that. The concern is going to be, and again, sort of a dynamic decision by the court. We know the facts, well, I know the court is not fully aware of all the facts, certainly not as much as the parties are. But there is evidence that he was up here having been suspended from school, and that's why he was here. If the state suggests something that then requires a response of why he was actually here, and without minimizing what may happen in the state's opening, if the state were to say he was up here on a monastic retreat, well, that, I think, would be an inappropriate glossing over of why he was actually here, then demanding a response for why he was actually here. So it is going to be only responsive that that information or evidence might become relevant, but that's really going to be in response to how the state presents it. I agree and will not preemptively discuss that Trayvon Martin was up here because he was suspended from school. I understand the case law, but the case law does not suggest that the state then has free rein to come up with some story that is not factually accurate, and that's the only concern.
Okay, the court will grant the state's motion in limine regarding school suspension records, and it will not be mentioned during opening statement, and it will not be mentioned at all without a prior ruling of the court.
Judge, as to paragraph B, any communications or evidence that Trayvon Martin had used marijuana in the past, we're asking the court to exclude that based on the cases cited, including Edwards and Lozano, which are both cited in the state's motion.
Okay, response?
Yes, certainly, Your Honor. That is particularly relevant to the theory of defense in this case and therefore should not be excluded. Let me go into some of the particulars in that regard. If I might just have a moment, podium. Thanks. I don't want to look at your notes, though, so I'll do this. There's a lot of evidence concerning Trayvon Martin's marijuana use. Now, in and of itself, if I were just to say that we have a picture of him smoking something, that might not be relevant. But since we have a lot of evidence that support the contention that the marijuana use has something to do with the event it is. For example, he had a toxicology report that is positive for presence of THC, the active ingredient, at a level that the state's own expert has opined it could have affected his behavior. That's one piece of relevant evidence. The second piece is that George Zimmerman, when he was first on the non-emergency call, said, this guy, speaking about Trayvon Martin as he was wandering in the complex, is acting strange, looks like he's on drugs or something. That's the second thing. The third thing is we have a 7-Eleven video that shows that Trayvon Martin is swaying and acting what might be interpreted by some, certainly by the jury, as being evidence of impairment. And again, it sort of comes together. There's also a lot of text messages, if they are otherwise admissible, a lot of text messages, Facebook posts, and whatnot, where he is talking about the ongoing use of marijuana. Matter of fact, there is evidence where he suggests to one of the witnesses that he had marijuana with him on the way up. He had hidden it from his father, who was going to search him to see if he had whatever he was bringing up here. So he hid it discreetly where it couldn't be found, and that he had smoked it while he was up here. That's evidence that would be presented to the jury, potentially, and that he was out of pot then and may have been looking for more up here in Sanford. So the idea of marijuana use is going to be intertwined with the behavior that happened the night that, for whatever reason, led to the altercation. The state says, my guy was the aggressor. We say Trayvon Martin was the aggressor. There are studies that suggest that aggressive behavior can be residual from marijuana use. So the idea of trying to extricate from this case the fact that Trayvon Martin was documented to be to have THC in his system would be an inappropriate restriction on our theory of defense, which is precisely that Trayvon Martin caused the altercation that led to his own death.
Thank you, Mr. Guy.
Judge, if I may respond briefly. The motion drafted here deals with prior drug use, not the toxicology in Trayvon Martin's system. We have a separate motion addressing that marijuana use. This deals with just prior marijuana use.
Okay.
Very briefly, the state's own expert had talked about the differential between chronic users and their behavior changes and one-time users. So to that extent, it may well become relevant that he may have been a chronic user, evidenced by what I just talked about.
Okay, the communication about previously used marijuana, the state's motion will be granted, that will not come in. C is have ever been allegedly in a fight.
Judge, and I would rely on the Munoz case, which I've cited for the court, as well as Singh, simply stating that specific acts of violence are inadmissible when the parties are unknown to each other, which is the case we have here. Because Mr. Zimmerman did not know Trayvon Martin, any specific act of violence that preceded his death would be inadmissible based on those cases, and we're asking the court to prohibit the defense from making any reference or suggesting that Trayvon Martin, prior to this date, had ever been in a fight.
Responses under Munoz that we are allowed to look into that and to bring it to the jury should we have evidence of a reputation for that, and there's certainly enough evidence we would suggest in the text messages, the Facebook post, and other witness testimony that it's going to suggest that Trayvon Martin involved himself ongoingly in fighting with other people. If we meet the criteria of Munoz, it certainly should be admitted and should not be limited preemptively before the trial.
How
Munoz
do you
allows
get past the authentication issue?
We'll address that.
And after authentication, you have a hearsay issue.
Thank you, and we'll address that. But the question is, if we can show authentication, and we do have people under subpoena who had these conversations with him, then that's our burden, but it's not a preemptive motion in limine to preempt us trying to do it.
But you have different things here in your, the defense response under C. You say one prearranged fight, and I think you have to, if you're able to get through the authentication and the hearsay, then those are the first two hurdles. And then you have a spectator or a spectator at others. I don't think any evidence of being a spectator of a fight would come into evidence. That would mean anybody who goes and watches any fighting match can have that brought against them as a character reference in a trial. So.
Presumably, however, you'll keep your mind open when we present to you the videos of him at these fights, not just as a pure spectator, but refereeing one and being involved in taping one where two buddies of his are beating up a homeless guy. So as long as we keep an open... Let me back up, and I apologize, Your Honor. This information, all of it, is only going to become relevant for the defense case according to how the state handles their presentation. If this case is limited primarily, solely, to what happened from the beginning of the non-emergency call to the end of the emergency call, which included the shot of Trayvon Martin, if that is what this case is going to be limited to, then this evidence may not be relevant at all. The question is, today, I don't know, quite honestly, nor does the court know how the state is going to intend to present Trayvon Martin that day. So preemptively, I don't think that you should limit it.
I understand the case on the rules of the court, and my ruling is it will not be mentioned in opening statement, and if and when it comes in, if the defense is able to authenticate it and get past the hearsay, evidence or testimony regarding the fighting would be allowed in. But has those hurdles to do. The next one is communicated or that has been attributed to Trayvon Martin and had screen names via social media, regardless of format and the contents of any such communications.
And Judge, again, this is more along the lines of the Weatherford case that I cited for the court, simply information that could be offered only to disparage or embarrass Trayvon Martin. It is hearsay, therefore, it's inadmissible. These are, again, items of evidence that George Zimmerman would not have been aware of. And again, we're asking the court to prohibit the defense from eliciting that type of testimony.
A couple of responses. Again, I think we're going to limit us, as hopefully the state will be limited in their opening argument in regards to matters such as this, but it may become relevant for a couple of matters. One, simply for authentication, as the court just mentioned, we may need to have items authenticated, which would be authenticated through his Twitter and Facebook accounts, the issues that the state brings mentioned to the court presently. But again, it may well become relevant according to how the states present this case. We have evidence of a cousin of his that may become relevant according to how the state presents the Trayvon Martin who was there that night. So I understand the concerns. It's just that preemptively, I think we should be limited in opening. Just keep an open mind for how we're going to present the case.
Okay. Neither side will mention this in opening statements, so to that extent, the motion in limine will be granted. And the court always keeps an open mind, but I will tell you that unless that screen name gets past the authentication, the hearsay, and the propensity for violence exception to the character evidence, it will not come in. So let me make that note. Had ever possessed or worn a set of false gold teeth?
Judge, I think that's pretty self-explanatory. Obviously, it wouldn't be offered to prove or disprove a material fact, and we'd ask that the court exclude it.
Response?
The same, Your Honor. I can't imagine how that would become relevant, but so I don't see it.
It isn't relevant, and you put it in your motion, so the
I'm sorry?
states, you put it in your motion, I guess it's been in both motions. So this will be granted. Neither side will mention it at all during the trial. The next one is any aspect of Trayvon Martin's school records in our performance in school. I think we've already gone ahead and done that one. The next one is the contents of any text message received or sent by Trayvon Martin prior to February 26, 2012.
Your Honor, I apologize. But the school records issue, you said that we don't address that?
I'm just reading, no, I said we already addressed, yes, the school records issue. Is there another aspect to it?
I don't know that the court had addressed that yet. Did I miss something?
Judge, I mentioned it during the very first paragraph regarding the suspensions, and I would again rely on Johnson.
Anything other than suspension?
Oh, certainly, yeah. There's a
Okay.
complete discipline. I don't know. I didn't want to preempt Mr. Guy because he didn't give his position yet.
Judge, I would just again rely on Johnson v. State. That it was a self-defense case, and in that case, the court found a 5th DCA case, that the school records or any mention of police reports associated with the school records would be inadmissible for the fact that the defendant in that case, as in this case, had no prior knowledge of the victim.
And the response is similar to earlier, however, more expansive than simply the suspensions. There are records in the school records dealing with potential criminal events and whatnot. And if, in fact, that gets to the point where it becomes relevant because of the history, saying that's our burden, it should not be preemptively denied that we have an opportunity to go into that. Remembering, again, that it would only become potentially relevant according to how the state handles their presentation of the case in chief.
Okay, the school records, other than the any regards to the fighting, the state's motion on limine will be granted. Neither party will mention any fighting in opening statements. G is the contents of any text message received or sent by Trayvon Martin prior to February 26, 2012.
Judge, again, that's a 401 argument that it's not evidence tending to prove or disprove material fact, as well as an 803 argument. It would be hearsay, inadmissible. Again, the defendant not knowing Trayvon Martin has an impact on that as well. But the only reason it could be offered would be to disparage Mr. Martin. So we'd ask that the court exclude that.
To be very clear, the theory of defense in this case is that, as I mentioned before, that this was started at the hands of Trayvon Martin. Therefore, if that is our theory of defense, as it is, then evidence of his familiarity with guns seeking to purchase guns, his ongoing fighting, as I mentioned earlier, but these all exist in text messaging, his use of drugs and his looking to buy drugs, all of that fits in squarely to what the defense is going to present as the reason why George Zimmerman was put in the position where he had to act in self-defense. We can't act in a vacuum as to who Mr. Trayvon acted as that night. Both the drugs and the history of his chronicity, his chronic use of drugs, and his familiarity with fighting, and to a certain extent his familiarity with guns is completely relevant to the theory of defense. So how could you keep us from arguing our theory of defense?
Because the rules of evidence keep you from doing it.
As long as you don't preemptively suggest and keep the burden where it should be on us to present competent, relevant evidence under 401, 402, 403, and 803, as mentioned by Mr. Guy, we'll take on that burden. But to do it here before you've even listened to what the evidence may be, I mean, you've acknowledged to us several times that you do not have a good factual basis for this case, as well you shouldn't. So the idea of suggesting that because it's a text message and it talks about something that a victim of a homicide said that it's not relevant is preemptively improper. That's all I'm saying.
The court is going to grant the state's motion in limine. Nobody should mention any of this during opening statement, and of course the court will always listen if it comes up outside the presence of the jury during the trial. H, the context of any text messages received by or sent by Trayvon Martin on February 26, 2012, until the relevance and admissibility of same has been ruled upon by the court. I think that's the same ruling as I had in H. The state's motion will be granted. Neither side will elicit that evidence during opening statements or during the trial in the presence of the jury, and the court will rule on it if it comes up outside of the presence of the jury. Okay, does that take care of that motion?
It does, thank you, Judge.
Okay. Next motion I have is state's motion to exclude improper opinion evidence. Who's arguing this for the state?
I am, Your Honor. We would rely on the motion itself. It's pretty elaborate in terms of what our opinion was, in terms of the defense attempting to get in people's opinions, police, et cetera, city's opinions, or witnesses within the city as to what should have happened or not happened. Our position is that we will rely on the facts that come in the trial itself as opposed to people's opinions of what should have been done or not done.
Okay, who's arguing on behalf of the defense? Mr. West?
Morning, Your Honor. Thank you. This is another one of those motions where, in general, we agree with the notion advanced that opinion evidence about the guilt or innocence of Mr. Zimmerman would be properly excluded on its face. However, there are circumstances where it may very well become relevant depending on how that witness's testimony is presented by the state or issues that are raised during the state's case that would make it a fair response or in the rebuttal aspect of the proceeding. Mr. De La Ronda mentioned that what he's seeking to do is keep out the testimony of a number of high-ranking law enforcement officers, city officials, and such that have formed an opinion about the appropriateness of the case from the very beginning, much less where it stands now. So, in principle, we agree, but we do believe there are circumstances that a state's witness may open the door by making statements about the investigation, about the decisions that were made. As we know, there's a special prosecutor in this case that came in after the Sanford Police Department had investigated the case, after Norm Wolfinger had the case, and that this is a highly controverted issue about whether this prosecution is politically motivated and whether it's going forward due to pressures that are regardless of the evidence.
How does that ever come in as being relevant?
I'm just saying that we don't know yet that it won't. We have, through our discovery process, learned about from witnesses that say pretty pretty damning things about the way the case has been investigated.
Okay, I don't want to get into that at this time. And I'm going to grant the state's motion in limine, and nobody is to mention it during the course of the opening statement. I can't imagine, although I will keep an open mind, but I can't imagine that there's any circumstance under which that will become relevant. But if it does, it will be done outside the presence of the jury and will not be mentioned in either side's case unless this court orders specifically that it is allowed. Okay?
Certainly.
Thank you very much. The next one is the state's motion in limine regarding toxicology. Who's arguing on behalf of the state?
Morning, Your Honor. If it
Good
pleases the
morning.
court, my name is Rich Manti on behalf of the State Attorney's Office, and I'll be arguing that one. Your Honor, this is the motion that Mr. Guy referenced and foreshadowed as it relates to the argument that there might have been a current impairment or current use of marijuana by the victim in this case. And I'll cite to the court, and if I may, I have one case that I'd like to present today as it relates to that. The case is Diaz, D-I-A-Z
I have
versus
it.
State. And Your Honor, reference was made earlier to the deposition of Dr. Goldberger, who was the state's listed toxicology expert in this case. And just to give the court a little, I think, clearer picture, Dr. Goldberger indicated that he did not believe that the victim, in fact, considered it probably not impaired. His indication was that there were two compounds in this case, one what I'll call an active compound for potential impairment and one inactive. He characterized both the active and inactive levels as quite low. He indicated that he did not think that if smoking had happened on the date that the sample was taken, which would have been the date of this incident, that it had been done even within 20 minutes. He characterized it as between an hour and up to 2 days. He said it is very unlikely that it was smoked anywhere close in time of death, and it also tends to show perhaps not chronic use. He would expect a much higher level of the inactive component if there was in fact chronic use. His best estimate, given what he called the flaws in the actual sample, in this case the blood was drawn from the chest area and not from a more desirable location from a laboratory perspective, understanding it was forensically drawn by the medical examiner. That he did not believe that there was any, that you would need about 5 nanograms or higher in a living person to demonstrate any kind of either acute use or impairment. Below 5 nanograms, you would need some kind of behavioral or other evidence to diagnose impairment, and here the level was 1.5, less than 1/3 of that necessary. I understand the defense wants to discuss their theory as to the behavioral evidence, and that is where the Diaz case comes in, Your Honor. The state's position is that unless the defendant testifies about A, his observations and of the victim, and B, his knowledge or somehow that this was related to the way the victim behaves when impaired by marijuana, that the evidence is inadmissible and should not come in.
Thank you.
What is clearly established by the evidence in the case is that Trayvon Martin's blood contained the active ingredient in marijuana, THC. It's also acknowledged that that active ingredient can cause impairment, and it would be necessarily enough for it to be active in his system. The metabolite on the other side of the equation suggests that he had smoked it relatively recently and that it was in the process of being eliminated from his system. There is an issue among toxicologists at what level is the THC clearly resulting in impairment. What Dr. Goldberger was talking about, if the level is 5 nanograms or higher, then it's presumed that there's impairment. What Dr. Goldberger said about less than that wasn't that it would have no effect whatsoever, but that he would, as the expert, want that level corroborated by other behavioral evidence. Mr. O'Mara talked about some of that behavior that's evident in this case.
The Diaz case, as I remember that, talks about whether it would have been appropriate under the facts of that case to ask the medical examiner what the blood alcohol level was of the decedent, and that the court ruled that it wasn't, because the issue of self-defense wasn't presented for the jury at that point, so that the medical examiner's testimony would not yet be relevant. So I'm not quite sure what Mr. Mante is saying, whether we have an apples and oranges situation. The motion to exclude or for the protective order suggests that it should not come into evidence at all. And we clearly dispute that and can offer expert testimony that the level in Trayvon Martin's blood is sufficient to cause some level of impairment, and that level of impairment could result in impairment of his cognitive thinking, of his judgment, and his behavior. There's also research that suggests in some individuals marijuana use or the withdrawal from marijuana use affects aggression. It makes someone paranoid or panicky. All of that is relevant information if, in this case, if we can otherwise establish the predicate. So, contrary to what the state says in its motion, Dr. Goldberger, or suggested just now, Dr. Goldberger could not testify conclusively when Trayvon Martin ingested the marijuana that was found in his system, other than that he did. He said it could have been within a couple of hours of the event. And that's consistent, we think, with the level of the active ingredient and the metabolite. There's some expert testimony available to show that relationship. We have the corroborating observations, the appearance that Mr. Martin made at the 7-Eleven, the observations that George Zimmerman made. And then we have Trayvon Martin's decision to attack George Zimmerman in an unprovoked way. Now, we'll argue throughout the case what the exact circumstances of that were, but there's clear evidence that Trayvon Martin made a decision, a bad one, but he made a decision.
I don't want to get into those issues here at this time. What I want to get into is whether or not the results of the toxicology report are admissible in evidence. And at the risk of cutting your argument short, and I apologize for that, but I am going to grant the motion as far as opening statements are concerned, that neither party will mention a toxicology report during their opening statements, and I'll reserve as to its use during the trial after I hear testimony from your expert witness. And that may be proffered evidence at the time before it comes in, and make a determination at that time.
I'm just processing what the court said.
Process and answer
Okay.
any questions you may have. So basically, again, in maybe simpler terms, that it will not be mentioned by either side during opening statements or even during voir dire, and the court will reserve as to its admissibility after I have an opportunity to hear an expert witness tell me exactly what the toxicology report, how it fits into the defense.
No.
Make a ruling at that time.
We understand the court's ruling is to opening. We certainly disagree that we shouldn't be able to talk about expert testimony and marijuana use in jury selection.
I think in jury selection you can ask a person whether or not they use marijuana, but as far as an expert's testimony, no, you can't. They can't comment on whether or not they will believe an expert. But you can inquire of the individuals whether or not what their opinions are on the use of marijuana, whether they use it or not, of course.
Well, I think, this isn't the time or place to debate that issue. I understand the court's ruling today with reference to mentioning the marijuana in Mr. Martin's system during the opening statement. May we readdress the issue in jury selection at the time that we are focusing on that?
You can't pre-try the case in jury selection, so if you're going to ask somebody who's a potential member of the jury whether or not they think an individual's use of marijuana at the time of this event should result in A, B, or C, is not permissible. But you can ask that person what their beliefs are about marijuana use and whether or not they use it.
And we would also, of course, want to voir dire on the idea of expert testimony itself. But again, we'd like to address those issues then, rather than preemptively making decisions that would dramatically affect the jury selection
I'm not
process.
going to have you ask this jury about specific expert testimony. If you want to ask the general terms of, do you believe an expert more than you would believe any other witness? Yes, you're allowed to ask that. But you're not allowed to ask them whether or not they believe in the certain type of methodology or scientific use of coming to an opinion.
I think I understand what the court's
Okay,
saying.
thank you very much. Now, there's certain state motions that I think need a Richardson hearing, so I'm going to go on to some of the defense motions. The first one I have is the motion for anonymous jury. Who
Yes,
wants
Your
to
Honor.
argue that one?
I hesitate to ask you whether or not you've read all the case law, because it was an enormous amount, and most of it's federal, and federal judges seem to take more time to say what state judges say in a page. Have you had a chance to review most of the case law?
Yes.
The anonymous jury concept is sort of like, might be likened to a sequestered jury on steroids. The basis for it, as is mentioned in a lot of the federal case law, it normally is there to particularly protect the defendant's right to a fair trial, and also to protect the jury, because most of the case law talks about organized crime or the high-level drug trafficking cases where the court has to acknowledge, or everyone acknowledges, that based upon the level of antagonism that the defendant would have towards the jury in organized crime, and if the drug cartels, where the jury would be in active fear for their life, that we go much beyond merely sequestering the jury, and that we actually do whatever safeguards we can come up with, and I listed a dozen or so to protect the jury. In this case, it is somewhat different. And the reason that I have a concern, and the reason for the request for anonymous jury, is I don't have a concern that Mrs. Zimmerman may have some, and I don't think the court or even the state would suggest that Mr. Zimmerman would be a danger to a jury upon conviction. My concern is that the jury itself is going to be put in a position, because of the social pressures that have been put on this case and the community pressures that are very well apparent already in this case, that the jury may be concerned not about what would happen if they convict Mrs. Zimmerman, but what would happen to them if they acquit him. And I'm very concerned that this jury may feel and respond to the pressures that have been put upon them already. There are people who are Facebooking how to keep on the jury, what to say in jury selection about why you're at a protest, for example, so that that doesn't get you kicked off the jury. So there are these very subtle pressures that are already being placed on the jury panel, and we haven't even gotten them here yet. So my concern is that Mr. Zimmerman is entitled to an anonymous jury precisely to make sure that he gets a fair trial, that this jury is not going to have to go home and say, yes, I was on the jury that acquitted George Zimmerman, because the pressures that have already been brought to bear on the system, I'm afraid, will be brought to bear on an acquitting jury. Granted, there are some pressures out there that may be brought to bear on a convicting jury, because this is not a one-sided pressure cooker that has become this case. But my concern, quite honestly, is ensuring that the jury is free to acquit without feeling the pressures. Now, the only limitation I find on that is that I don't think that this court can prohibit a juror after the case is over from acknowledging that he or she was a juror. I don't think that you can impact or that you can prohibit them, and that's their call. I think they probably retain that right. It doesn't address the stealth juror mentioned in my motion, but that's just something that's come to pass in the past 10 years, and we as litigants and you as the judge is going to have to hope and figure out how to avoid getting what is now got its own terminology, a stealth juror, one who just wants to be on the jury so they can do something with that experience afterwards. But short of that, the request that is inherent in my motion is that we keep them completely limited, that the media, I don't want to recount everything, I know you've read the motion, we do everything possible to keep this jury from infection. Now, the state's going to get up and say, well, Mr. O'Mara talks to the media all the time. And I said a few weeks ago, if we can go back 40 years and not have the media involved in this, I would, but we can't do that. So we know the Martin family has been very vocal. Matter of fact, as late as last night, one of their attorneys was tweeting to every media person who is going to be covering
I
this.
find it very hard for either side to point fingers on that issue.
Agreed.
So please don't go there.
As long as you understand that I don't want the finger pointed solely at me. We have that agreement, I presume, from everyone involved.
I don't know what the state's position is, and I'll
Okay.
hear that in a moment.
So the concern that I have is, again, in making sure that within the context of extraordinarily high profile and highly publicized case, that the 6 people who really need to do their job on this case fairly and impartially are as protected from those external pressures as we can make them. And unfortunately, I don't think that sequestering them in and of itself, though it's a great start, is going to be enough. My request, as absurd as it sounds, is that the entire Venari panel be sequestered once they get here on June 10th. I know the expense is absurd. I know the logistics are absurd. But my concern is I believe that a high percentage of people who are on this panel are going to be sought after by the media. They're going to be questioned by the media. We know from the recent history of the Casey Anthony case that media actually got to the very hotel where the jury was sequestered. They didn't get to the floor, but they got to the hotel, a number of them. And unfortunately, their First Amendment right as the Fourth Estate, they take to heart. And they believe that whatever they can get, they will. You may have seen the coverage of the one juror in the Arias case last week. He went out the front door for some unknown reason, but literally wouldn't say a word, with no comment the whole time. But there was 30 people around him like bees around a queen bee trying to get any word out of him. It's going to happen in this case. I don't want it to affect my client's right to a fair trial, so everything I'm asking for in that anonymous jury motion, I'm asking this court to consider and to institute whatever the cost, because there really is no greater cost than diminishing my client's right to a fair trial, particularly in a case where everybody is going to look at this case. It has been said by Mr. Crump that this is the most significant civil rights trial of the century. I disagree that it's a civil rights trial at all, but whatever. If the focus is, the reason for that comment was because people who listen to those of us involved are perceiving it that way. And if they perceive it that way, and they don't perceive that it is a fair result, then, as I've mentioned before, the system is the one that's going to suffer, one way or the other. And my concern is that the 6 people that we have to be able to discharge their very difficult duties in a case like this without outside influence. And I want to be preemptive because it is going to happen.
Okay, I understand your argument. Who's arguing on behalf of the state?
I am, Your Honor. And on behalf of the state of Florida, we're not going to be commenting about attorneys, Mr. O'Mara, Mr. West, or anybody else on purpose. We have taken our position that we don't comment to the media. We're going to let our talking be in the courtroom, which I think is the appropriate place for that. Regarding the anonymous jury itself, let me start off with one of the things that Mr. O'Mara commented about. I guess the request is that all 500 jurors be sequestered. I don't know how that's physically how we're going to do that, just from a logistics standpoint. How are you going to sequester for, what, 3-4 weeks? We're going to book people into hotels or somewhere. It's impossible. It's unrealistic. But regarding their motion, as I understand it, and I'm inquiring through the court of Mr. O'Mara because I'm unclear in terms of what they're asking for in their motion. Are they asking that when we question the jurors that all the media is excluded from the courthouse and everybody else is excluded, and so we'll be able to ask Mr. Joe Smith, where do you work and all that? Is the request that we get their names, but nobody else can get it? I mean, if that's what, I just want to make sure in terms of what the defense is requesting here. That is, are they requesting that all the media be excluded, or that we do it somewhere in the court's chamber with nobody else in there except the attorneys, where we get to ask the jurors questions? Because I think it is germane in terms of their place of employment and their name. We need to find out who they are from the state and the defense to find out a little bit about them. So if the request is just to keep them anonymous once they're picked and somehow that their name not be publicized, I have no objection to that. But I think both sides are entitled to find out who these people are. And I think we have to do it in open court. I've never heard of it not occurring in open court. I know that we can do it in terms of individual voir dire of jurors where the other jurors are excluded, but I don't know that I've ever heard of jurors being questioned where everybody else in the courtroom is excluded except for the court and both parties. I've never heard of that happening. Maybe there is some law out there or there is some case out there. So I guess in theory I have no objection at some point that the jury, I completely agree that the jury should be left alone and left to do their job. As Mr. O'Mara said, there's been threats, there's been all kinds of stuff in this case. Quite frankly, as Mr. O'Mara conceded, it's not just from one side, it's from both sides. I fear the jury, in convicting this defendant, will then fear that something will happen to them because there are people out there that have made comments about what will happen if Mr. Zimmerman gets convicted. So I think it's fair for both sides. But I think the court can take steps to, as I'm sure the court will, to ensure the safety of the jurors, to ensure that this trial is tried in a courtroom and not outside the courtroom, and that outside forces are not able to influence the jury's verdict.
Thank you. Mr. O'Mara? Oh,
May I speak, Judge?
yes, you may.
Scott Ponce, here on behalf of the media organizations. We hadn't been served a copy of this motion. I didn't know particularly it was coming up today. It's something I would have enjoyed the opportunity to brief. Working backwards from Mr. De La Rionda's points and then going to Mr. O'Mara's, voir dire is an open proceeding. There's no case that talks about voir dire being able to be held with the courtroom empty, with the press and public excluded. Florida cases are really clear, and I was able to grab some decisions from my phone sitting over there when I heard this came up. The Times decision, 632, Southern 2nd, 1072. Sarasota Herald Tribune, 916, Southern 2nd, 904. Both of those decisions talk about the fact that if juror information is discussed in court, the press is free to report that. Otherwise, an order saying you can hear it, press, but you can't publish it, that's a prior restraint, and the decisions are clear that that's a prior restraint. Moving more towards Mr. O'Mara's points, the outer limits of Florida law on this, and the decisions I cited to you talk about that. The outer limits of where Florida has gone on this is that during the jury selection process, the clerk is not allowed to release the names of the people on the veneer to the public. The court has them. Counsel for the parties have them. And during voir dire process, the names aren't said aloud. That's the furthest Florida law has gone on an anonymous jury. I'm aware generally from having dealt with this issue years ago of some of the criminal mafia type cases from federal courts that Mr. O'Mara mentioned. I don't have those in front of me, so I can't look through them and tell you why they are or not applicable here. But I will say this, the Florida decisions have not gone that route. This anonymous jury or a sequestered jury on steroids is far beyond anything Florida's been willing to do. And it's something, if Your Honor wanted me to provide you briefing on it, I'd be happy to, but that's off the top of my head. Doesn't have much hair on it. All I have.
Okay, thank you.
Your Honor, if I might briefly, Rachel Fugate on behalf of the Orlando Sentinel. Just want to concur with what Mr. Ponce said about the precautions to be taken in advance. And Florida courts do not allow juries to indefinitely remain anonymous. And Mr. O'Mara brought up the Casey Anthony case as an example. In that case, those names were eventually released after a cooling off period. That was also a very unpopular verdict. Judge Perry noted that there had been threats, not only against the lawyers, but to the jurors as well. And while he may have disagreed with the law, acknowledged the law required that those names were eventually released. So we would likewise object to a completely anonymous jury and think that there are precautions that the court can take in advance to protect the safety and the sanctity of the process beforehand, but would object to an indefinite closure or secrecy of those identities.
Thank you very much, Mr. O'Meara.
A brief response, and I know the court's aware of this from the case law. It is, in fact, the defendant's right and to have a fair trial, obviously. And the concern that has always been addressed in the anonymous jury case law that I presented is the presumption that the jury needs to be protected from the defendant. And then they try and come up with ways to craft that in a way that doesn't give the jury the insider idea that it is the defendant who is dangerous, such that they need to be protected from him. That obviously is not the case here. So to the extent that that needs to be affirmatively waived, this concern about the defendant's right to have a fair trial and how we're going to craft that with the jury, I believe that we can craft an appropriate instruction to the jury that really just focuses on the real reason, which is that of the enormous pressures on the case. So that's not a concern of mine, but the idea about making sure that this jury doesn't have any concerns is.
Thank you very much. As far as the defendant's motion for anonymous jury, during the jury selection, the court and the attorneys will refer to the prospective jurors as by their juror number and not by their name. And of course, according to procedures, the jury, the press will not take any photographs or moving pictures of the faces of the juror during the voir dire. The court is not going to sequester the entire veneer. And the rest of the motion the court will take under consideration during the jury selection process.
There are, if I might, I understand the court's ruling, there are a couple of procedural that we may need to address earlier since we don't have a lot of time between now and the jury. For example, that the clerk is instructed to keep all that information completely
The
confidential.
clerk already does that. All they give out is the juror number. Am I correct, Grace?
And that there are signs posted reminding the media where they can and can't go. There's just some procedural matters or logistic matters that if we address them ahead of time may avoid it. Because I've had a case where
The court is very aware of the concerns in protecting the rights of the defense and the state, and the court will abide by that and do everything to ensure that that will occur, and the rights of the press.
And just a quick question so we understand. The prohibition on photographing the jurors is during voir dire.
During voir dire.
well,
Well, it's during the trial.
and during the trial.
You can't photograph the faces of the jurors
In the courtroom.
in the courtroom.
Or sorry.
They won't see them outside the courtroom.
And here's, I'm sorry.
When he's done, I do want to respond.
Here's my concern about that, and again, this is not something that I was aware was coming up today. We weren't sure of the motion. The rule of judicial administration in dealing with photographing in the courtroom refers to the trial participants. That includes jurors. There's a specific test that's used by the Florida Supreme Court in determining to what extent you can photograph jurors. It's the qualitatively different test. That the effect on a juror is going to be qualitatively different than the effect on anyone else who appears in the courtroom. Judges, parties, witnesses. It's an evidentiary test. I'm not, again, I haven't seen any of the motions that have been filed dealing with this. But I'm just not sure what the legal basis is for the finding right now on the record, as I understand it to be, that the qualitatively different test has been met here. And again, I don't have cites with me because I didn't know
Okay, well
this was
then show
coming
me a
up.
case.
I will.
Okay, thank you. The next one is the motion to allow jury inspect the incident scene.
Yes, Your Honor. Again, the motion itself, I think, is
Isn't
self-explanatory.
this a little disingenuous with your prior motion?
Sure, absolutely a concern that the court needs to address. However, again, since my client has a right to a fair trial that has to be protected at all costs, we have a jury that I want to be anonymous, and we may have an opportunity to bring them to Retreat View Circle if need be, because I think if you look at, again, the motion discusses this, the unique nature of this case, it happened over a very short period of time, a few minutes, and in a very limited geographical area. And the conditions were quite unique, the darkness and the rain and whatnot. I'm not sure that you could cause it to rain for the view, but we can probably do most of what we need to do to emulate the circumstances that they existed that night. I will tell you that I am considering seeing if there are some alternatives to a jury view. I think it is necessary in a case like this, even with the extraordinary measures that would need to be taken to assure their continued security. But for today's purposes, since we don't have those other possibilities in play yet, hopefully very soon, I think that the view may well be determined to be appropriate. And again, I hesitate when I start talking about facts. You tell us you don't want to hear about the facts, but I feel the need to tell you about some of the facts of the case so that you get the reason for the view.
Well, let me just tell you my thoughts on a view, and especially when I said it's disingenuous to your motion to keep an anonymous jury. The sheriff's office is able to provide an enormous amount of security. But if you're taking members of a jury to a scene, first of all, the events occurred February 26th in the evening or nighttime hours. This is June. It stays lighter later. To get that type of darkness could be 9:30, 10 o'clock
Probably
at
10 o'clock.
night. Your may or may not rain, but the more importantly is during a jury view, nobody is allowed to speak. So you just point here, point here, point here, and have the jury move around. Also importantly, a lot of these people who will be testifying were witnesses who either were outside of their homes or inside of their homes. Nobody's allowed to tell them who was where, and nobody's allowed to go into their homes to see or hear nothing that's occurring outside during the jury view. In keeping with the anonymity of the jury, how do you prevent people who live in that area from using their cell phones to take pictures of the jurors and posting their faces on the internet and asking, do you know these people? How do you prevent the press from being overhead in a helicopter, coming down and posting those people's faces and what they're doing, and the comments that may be what they're seeing and what they're hearing? I think it's a logistical nightmare, and for those reasons, I am going to deny it.
If I might, because I do have a couple of just logistical responses. And I'll give you one easy one. It would be very easy, because of the geography of this location, for the sheriff's department to literally have the court. It is mandatory for the court to be there. It is optional for the defense and prosecution to be there, but I would ask that we be in the van, which is what I'm going to suggest to the court, that literally the people be put into a secure van, blacked out windows if you want. The location where all of this happened is literally all on the street. Then you get to a T intersection, which the van could drive on, and then you go down the T intersection, which the van could drive on. That logistically would be very protective because the sheriff would be with them. They would not be exposed to the outside influences, and they would get the view that I think they need. There is, again, another alternative that I'm working on right now. I'm not trying to be secretive to the court about it. It's just,
I can think of a million alternatives, one of which is to go there and view the scene on video and show it to the jury. Let me hear from the state.
Your Honor, the court has already articulated the reasons why the court should deny their motion. It's impossible to recreate what happened out there in terms of from a darkness, rain, et cetera, vantage point of what the witnesses are going to be testifying. So we respectfully disagree with the comments made in the motion in terms of the significance of what they've stated. Our bottom line is you cannot recreate what happened there in terms of having a jury view. It is not like you're taking a jury to a room which is controlled and was a crime scene, an apartment, an actual room itself where you can control everything. Here you have outside influences, God basically, influencing what happened out there. And you cannot recreate that. We could all pray to God and say, let's have it rain and let's wait until this time, but I doubt that the exact conditions that occurred on February 26th of that year of 2012 will occur again. So we respectfully ask the court to deny their motion.
Thank you. Again, the court is going to deny the motion. There are serious logistical problems in allowing the jury to view, and there's not much to be gained in allowing it. It would seem confusing at best to the jury and impossible at worst for the jurors to get a sense of where each eyewitness would have been located at the time of the events. So the motion, as I stated, is denied. Okay, the next defense motion is to allow additional witnesses' disclosure. Is there any objection from the state?
Your Honor, there is none, with the caveat that these witnesses be available to be deposed. The last time we were in court, which was last month, I believe, the court granted or asked the state whether we objected to allowing this. There was 5 additional witnesses. 3 of them we were familiar with, the other 2 we were not. We have still been unable to set the deposition of those witnesses nor receive any reports, et cetera, regarding those witnesses, even though we have tried repeatedly to request defense to provide that to us. So with the caveat, we've got time before next week, before the trial starts on June 10th. As long as they're available, we would be glad to depose them.
The defense motion to allow additional witness disclosure of GZW-LL and GZW-MM will be granted. They need to be made available for deposition or conversation with the state. Failure to do so may result in their not being allowed to testify. Then I have the motion to allow defense motion to allow expert witness testimony at today's hearing. I think that we've already resolved this issue. Am I correct?
Yes, although what we haven't resolved is the Fry hearing issue itself.
We will resolve that, okay. Next one is defendant's motion to establish a reasonable expert fee. Has that been resolved by the parties?
No, Your Honor, it has not.
Okay. Mr. West, you may proceed.
Your Honor, as the motion sets out, Mr. Tom Owen has been disclosed by the state as an expert witness in the area of speaker identification. We attempted to arrange his deposition and were told through the state attorney's office that Mr. Owen required a prepayment of $3,300 in advance, prepayment, prior to him sitting for his deposition. And we sent some emails back and forth and got no relief. So that seems to be where that stands. We anticipate the deposition would take a couple of hours. That's hard to anticipate, but for Mr. Owen to require $3,300 for a 2 or 3 hour deposition is well in excess of any reasonable fee that he could charge, and effectively denies access to this witness by the defense.
Does he live in town or out of town?
He lives in New Jersey.
Well, how's he supposed to get here for a deposition?
Pardon me?
How's he supposed to get here for a deposition?
When the deposition was originally scheduled, I was going to go to New Jersey. We would likely accommodate that through video or telephone. The fee was for his appearance, not for traveling to Florida. It was his, as I understand it, that was what he wanted to sit in the chair to answer questions. In the motion, I also suggested a reasonable range. The fees for these types of experts seem to be all over the board. Recently, an expert we talked with charges $100 an hour, and I know of experts that charge closer to $400. So I guesstimated in the motion suggesting a reasonable fee would be between $250, $400. I would suggest, since Mr. Owen is not a PhD or otherwise holds advanced degrees in his area, that the lower level would be more appropriate.
Thank you. Who's responding on behalf? Thank you.
I will, Your Honor. To please the court, to my knowledge, the defense has neither requested nor been granted indigency status. The fee quoted by Mr. Owen was for essentially setting aside his entire day, perhaps more than one. If the recent deposition is any indication, it will be more than one. It was his request that be done up front because he normally consults and does other things during his day, and so he's forgoing that income. As far as the defense's request as to him specifically, my understanding is they attempted to retain him themselves earlier on in the case, and he gave them the same answer then that he gave now, is that I would like to be paid for that. So I don't know what the complaint is specifically that he charges more. Obviously, that's something that's germane for cross-examination, but to tell a witness how much they could or should not charge for their time on behalf of a private litigant, I'm not aware of any, and I didn't see any cited in the motion, any legal authority for that, seeking that compulsion.
Thank you. Mr. West? It's very hard for a court to tell somebody how they're supposed to earn a living. I think the court has a lot more control if the court is paying for the services, but
Well, it's holding Mr. Zimmerman hostage, frankly, for him to charge such an enormous amount of money just to sit in the chair, whether it's a 1-hour or 5-hour deposition. A reasonable hourly rate would allow us to go forward and take his deposition. The Orlando Sentinel hired Mr. Owen at the beginning of this case. His opinions were in the newspaper. He's never prepared a report that I'm aware of. And we're trying to talk with him to find out what he did in this case.
maybe you need to have a conversation with him of what it would be on a hourly basis broken down, because if he set aside $3,300 because he thought it would be the entire day, then his amount may be different. If you guarantee him it'll only be 2 hours and you pay him,
$720,000 a year in income. Sorry,
it's okay if you need to speak to Mr.
it's just $720,000 a year in income. I don't think he makes that.
I don't know what
The
it
attempt was
is, but-
made, Judge, in the sense that Mr. Manta and I had an exchange of email correspondence, and there apparently was no relief from Mr. Owen. I suggested whether or not Mr. Owen would insist on that fee and that it be paid in advance regardless of the length of the deposition.
Well, if you're willing to go up there or he's willing to do it via Skype, then there is no travel time on his part, and it's not necessary for him to keep the entire day open for this deposition unless you're going to use that entire time. So it's almost an incentive for you to get down to business and use yet less amount of hours. So maybe there's something you could work out that you give him a $3,300 deposit and are reimbursed whatever funds you do not use for depot time.
So the court will essentially allow Mr. Owen to set whatever rate he chooses.
Well, I don't think he could go beyond that which is acceptable of expert witnesses and.
That's what I've suggested, that a reasonable range would be.
I don't know what they do in New Jersey. I don't know what their fees are based and if that is usual.
Well, we know that at least one expert in New Jersey charges $100 an hour, and he has an advanced degree.
I'm not going to have a hearing on what he says. It is what it is. What I'm saying is that if he is fearful that he has to set aside an entire day and lose 6 hours of business earning a living somewhere else, I understand that. So if you were to give him the $3,300 with an understanding that if it's only 2 hours, X amount gets reimbursed to you.
So in other words, the court is establishing a reasonable hourly rate, but we just don't know what that is yet. So
I don't know if I would say it like that. The court is saying that you will, if the representation is $3,300 is for the entire day and you only use up 2 hours, that there has to be some type of an hourly rate determined.
well, I suppose the state has not sought to clarify that. I suppose we can if Mr. Owen will answer our questions. We're sort of stuck at that point now. But we can't take his deposition at his rate of $3,300 paid in advance before he'll sit to answer a few questions. And so we effectively.
I'm not aware of any cases that say that for cases where the court is not the one paying the bills, that I have to make a determination as to what an hourly rate would be.
We'll have to address that separately.
Okay. So my initial ruling is that I'm not going to establish the expert fee. Let me go ahead and do the state's third motion for a gap.
I've grabbed some of the sites, Your Honor, about the juror photographing, if you would like me to give them to you.
Sure.
The first is In Ray Post Newsweek stations, reported at 370 Southern 2nd, 764. It's the Florida Supreme Court in 1979. The presiding judge may exclude electronic media coverage of a particular participant only upon a finding that such coverage will have a substantial effect on the particular individual, which would be qualitatively different from the effect on members of the public in general, and such effect will be qualitatively different from coverage by other types of media. Other decisions, Your Honor, are...
That include the jury?
Yes. The Post Newsweek also went on to say that a juror is considered a trial participant. Other decisions, Your Honor, are Florida Supreme Court's 1981 decision in State of Florida versus Green, 395, Southern 2nd, 532. That first, a jurors, the qualitatively difference test requires an evidentiary showing that photographic coverage of a participant, including a juror, would have a substantial effect upon the particular individual, which would be qualitatively different from the effect on members of the public in general, and such effect will be qualitatively different from coverage by other types of media. The decisions go on, for example, the Florida Supreme Court's decision in 2002 in Chavez versus State of Florida, 832, Southern 2nd, 730. Talking about before photographic access to a courtroom can be restricted, the trial judge must provide the media with notice and an opportunity to be heard, and that the application of the qualitatively different test requires an evidentiary hearing. Other decisions, not Florida Supreme Court ones, are
What does the Chavez case have to do with taking the facial
Yes.
photographs of jurors?
yes, ma'am. Yes, I'll pull it up. 32, 7 seconds. 7. The Green decision I cited to you does, and
The Chavez.
Chavez does also.
Might respond, Your Honor?
I'm going to reserve ruling, so if you have other cases
Uh,
for that aspect of,
Sure, I don't know if he's confessing error, if he's suggesting that this is not a qualitatively different effect on this jury in this case, or if he acknowledging that it is, or do we really need to have an evidentiary hearing on the question of whether or not this jury in the State versus Zimmerman case, the way it's been handled so far, is not qualitatively different as to the effect it's going to have on that jury.
all right, what I'm going to do, since I haven't read those cases, and the court has always operated under the rules that the press does not videotape or take photographs of the members of the jury, specifically their faces, I will set this issue for hearing this Friday, the 31st at 1:30. Okay, then we have the state's motion requesting a court order defendant to comply with discovery obligations. I have defendant's motion for sanctions against the state attorney's office for discovery violations and request for judicial inquiry violations. Those two will require a Richardson hearing. Are you prepared to do that now?
Yes.
Defense
Yes,
is
Your Honor.
ready? Okay, well then let's go ahead and start with the state's motion requesting a court order to order the defendant to comply with discovery violations.
Your Honor, our motion speaks for itself. As noted in the motion, due in the deposition, the state has repeatedly requested copies of, or an opportunity to inspect items that were shown to witnesses, and that was not done until the witness was then shown, until we repeatedly objected, and then finally we were provided. We would just request that it be done in a timely fashion. I will compliment the defense that within the last week, they have disclosed, I think, 3 supplemental discoveries listing all kinds of evidence that we were requesting from the get-go. I guess the reason I filed this motion, Your Honor, was that recently, on May the 3rd of this year, while taking a deposition of a witness, we found out that the witness apparently had made a drawing. This witness, I'm not going to mention his name, but stated that he had met with the defense counsel and had provided a drawing to defense counsel. From what we understand is this document does not exist. Apparently, either the witness is mistaken, lying, or the item if the drawing was misplaced somehow. But from what I understand from, I believe it was Mr. West, indicated to us at the hearing, because I believe Mr. O'Mara wasn't present, that the document doesn't exist. We want to make sure that that document doesn't exist, specifically that drawing by that witness.
Okay, I remind both sides before I hear the defense motion regarding discovery 2 of Rule 3.220D and J. And those are the obligations of both sides to provide the discovery, the timeliness of that, and that it is a continuing duty to disclose. I would hope and think that by this time, with trial beginning on June 10th, that there is no other discovery that's out there that has not been disclosed. So your motion, the state's requesting a court order for the defense to comply with discovery obligations is granted. If there are any violations, the court will address those on an individual basis. Then we have the defense motion for sanctions against the state attorney's office for discovery violations and request for judicial inquiry into violations.
Your Honor, on the prior motion, is the court saying there will be additional matters addressed later, or just generally saying both sides should comply with Rule 3.22?
Well, the court has said almost at every hearing that both sides shall comply with Rule 3.220, yet at every hearing I have another motion filed by somebody saying that there's some kind of discovery that has not been provided. 3.220J requires a continuing obligation on both sides, and I expect both sides to abide by that. The next one, as I said, is the defense motion. Mr. O'Mara, are you arguing that one?
I am, yes, Your Honor. The motion is going to require some testimony, but let me preempt or start with some of that by stating that we were before you on a motion for specific discovery last hearing, where we asked the state to advise us through the court whether or not they had received any information and any reports concerning Trayvon Martin's phone. And you'll remember that Mr. West was very specific in presenting that motion to you to have those questions answered. He actually twice requested the court for a very focused inquiry in this regard. And you actually asked Mr. De La Rianda, and he said at first that he had not talked to Selbright and that there was nothing done regarding any information that he'd gotten regarding Trayvon Martin's phone or any other reports. The reason for that inquiry and the specificity for it was that we had just become aware of some additional information in this regard. You then were very specific and asked Mr. De La Rianda at Mr. West's request, did he get any information regarding this phone from anybody? And he said no. We know that to be false. And we have some evidence to present to the court that the state attorney's office received information, gathered information from a report from the Selbright software that they had.
Okay, well, let's go ahead and take the testimony.
Okay, if I might, I'll need a moment to get the witness, Your Honor.
Yes.
And then I also, does the court, I have the video, if the court needs to be reminded of Mr. De La Rianda's response. Do you recall it, that he categorically told you that he did not speak to anyone and did not get any information from anyone?
I do remember.
I have a moment, Your Honor?
Yes, you may.
Thank you for the moment, Your Honor. Would call to the stand Wesley White.
Mr. White, if you'll please come to the podium, raise your right hand to be sworn.
I do, so help me God.
Okay, and if you'll please come take a seat in the witness.
As he approaches, Your Honor, this is preliminary testimony to establish the need for judicial inquiry. There will be some other witnesses that will not be present today in just a second, but I just want to let you know the purpose of this inquiry. State your name, sir,
Wesley White.
and your occupation.
I'm an attorney
Where do you practice?
in Nassau County, Florida.
And had you at one point been employed by the State Attorney's Office for Duval County?
That's correct.
Okay. No longer employed there?
That's correct, as of December of last year.
Okay. Did there come a time when you contacted my office and spoke to me about an event you wish to discuss?
I did approximately 5 weeks ago.
And if you would, tell the court what that information was.
Your Honor, it came to my attention through a client that there existed certain materials generated by my client, in other words, a report that relates to this case, which may have not been turned over to the defense.
And was that information regarding reports generated through Cellbrite software?
That's my understanding.
Okay. And did you then question me about whether or not I was aware of the existence of certain pieces of evidence?
I asked you if you had received 3 photographs and deleted text messages, and I described those photographs.
And would you describe those for the court?
They were a photograph of a firearm in someone's hand, a photograph of an underage female, and a photograph of drugs.
Did I advise you that that information had not been forwarded to me by the State Attorney's Office?
Yes, you did.
Do you recall when that report was generated by the person who contacted you?
My understanding.
You would object at this point if the hearsay?
Thanks.
Your Honor, again, it's for the initial request for a judicial inquiry. I would ask that you would relax the rules of evidence for this purpose because the witness, as you're going to find out, obviously has some concerns that we'll address. If you would like to recess after having some more inquiry, we can, but for the purpose of whether or not this court will undertake a judicial inquiry as to the discovery violation, I would ask that he be allowed to testify concerning that information.
I would have the same objection, Your Honor, he's talking about hearsay.
It's a court proceeding,
I,
and rules, and that is hearsay.
as to the timing of the report, Your Honor?
What anybody else told him.
Okay. Did you then discuss this matter further with your client?
I did.
And who is your client?
My client is Ben Krybos. He's the IT director of the State Attorney's Office for the 4th Judicial Circuit.
And was he working for the State Attorney's Office when this report was created?
Yes, he was.
Ran hearsay.
Are you aware of who that report was given to?
Mr. De La Ronda.
And do you recall how long before your contact of me the report was generated and given?
Your Honor, I
Months.
object to this, all this line of questioning regarding hearsay. We're having now an attorney talk about what he discussed with somebody else.
Then, Your Honor, I would move to suspend the hearing for today's purposes to, now that we know the witness's information, he was only disclosed to me in this hearing, as Mr. White would suggest he would only do pursuant to the subpoena that I issued, and once it was placed under oath. I would ask that the inquiry be continued by the court and that you issue a subpoena in stanter for the witness identified as the person who created the report, gave it to Mr. Del Rionda, and which was not forwarded to the defense.
Okay, and when is it that you would like the court to do this?
I think you could probably get him down here this afternoon. I would imagine he's still, at least momentarily, a state employee. And if you were to request his appearance, I don't mind it being by phone if the court will allow. But I think that information has to be presented to the court because of the magnitude of the violation.
I will continue this hearing on the defendant's motion for sanctions for Friday, February 31st at 1:30.
And, Your Honor, would you issue a subpoena to assure,
Provide one to me, I will.
Your Honor, there may be some cross-examination, however. I don't want to preempt that.
Are you finished with your direct examination?
If we're going to continue the hearing, yes.
Okay.
Your Honor, I have a conflict on May 31st. My daughter is getting married that day, so I would just request any day other than that. If we could do it the following week, we have already scheduled time potentially with the court. And I also would like to cross-examine this witness regarding just his association with the state attorney's office. And I'm not going to get into what hearsay stuff,
Well,
but.
for the, let me then just get into the request. Basically, I'm going to call it for the Fry hearing. The court has set aside June 6th and 7th for that. Do you think that we can accomplish this on either one of those days?
I think it's very relevant and needs to be addressed.
Well, I'm not asking about relevance. I'm asking about time, the time to do it.
That was my way of saying yes.
Okay,
Sorry.
thank you. Can you come back on, I guess we could do it in the morning of the 6th.
Your Honor, I will, if there's, for some reason I cannot, I will let the court know. I believe that I may be in trial at that time, but if,
How about on the 7th, which is the
well,
Friday?
I don't recall which days at the moment, but I will make every effort to be here, and absent something extraordinary, I will be here.
Okay, we will continue this hearing on the defendant's motion for sanctions for either June 6th or 7th. The parties will let me know which date is amenable to the witnesses. If you'll get me the subpoena, I will sign it.
Yes, Your Honor.
Okay, thank you very much. You'll be excused for the day. All right, and the other one was for the Fry hearing, and I am going to conduct a Fry hearing, and it will be on the 6th and 7th.
Yes, Your Honor.
Starting on the 6th, going into the 7th if it need be. Do we need to discuss anything else on that issue at this
You're
time?
allowing witnesses on both sides to appear by video conferencing?
Yes, both of you have agreed to that, and the court will allow it.
We're just making sure we have the logistics down right so that it's as productive as we can be. No, Your Honor.
Okay, so anything else from the state on the Fry issue?
No, Your Honor.
Okay, so this one gets continued to June 6th or June 7th. All right, we have the state's motion for a third gag order. Third motion for a gag order.
Your Honor, the motion speaks for itself, and let me just make it absolutely clear that we believe in the First Amendment, we believe in free speech, we believe in freedom of the press. I think we are now at the eve of trial. I previously filed 2 motions for gag orders. They were both heard by Judge Lester, in your honor, and both denied. Our position is that, as I cited in my motion, there were 2 recent examples which I think were pretty blatant, in that I don't know if we're going to be able to try a case without there be commentary about what occurs in private hearings with the court. Let me just stress this again. The court had a hearing where only the parties, that is the attorneys, and I think there were some security officials were present, and obviously a court reporter, in which certain matters were discussed. Right after that, there was a disclosure by one of the defense attorneys to the media about what something had occurred. If we're going to have a courtroom and we're going to have a trial and we're going to have proceedings where we appear in front of the court and there is some discussion about a matter that obviously is being tried to be kept from the jury, et cetera, and then if there's a discussion by an attorney outside of the courtroom, I think that's totally improper. So that's why I think it's important to be, I guess, why I'm asking for a gag order. The other key point is defense counsel also, the other defense counsel also on that day made comment about witnesses, about the credibility of the witnesses' testimony. I think that's totally inappropriate. So while I understand there is freedom of the press, and I realize they have a job to do, and we all appreciate that, I think at some point it factors into us having a fair trial. That is, the state and defense having a fair trial. The defense counsel in this case has repeatedly gone out and had public disclosures or commentary about the case. The argument was made in prior motions that, oh, we're just commenting about what happened in the courtroom, et cetera. I think an attorney cannot comment about the credibility of a witness or the believability of a witness or the reports authored by that witness, and that's what has occurred here. So there's two things that have brought this issue to light in terms of my reason for requesting now a third gag order. We are at the eve of trial. There's been all kinds of publicity on this case throughout, but now we're trying to prejudice the potential jurors. Now jurors are, if they hadn't already, focusing in on this case, especially since they've gotten the summons. There has been a release and commentary about evidence, which I would submit is improper, but so I would argue that the gag order should be granted at this time. Thank you.
If I might, Your Honor. The court is well aware that after the hearing, when we talked about the sequestration of the jury, and it was the main issue, Mr. West, who normally does not interact with the press, was asked a question. And it was coincidental to the fact that we just talked about it, and he said, yeah, we're going to sequester the jury. A question, quite honestly, that Mr. Delariando...
You're saying it here in court again, and this court's, the reason we had a in-camera or in-chambers meeting was to discuss scheduling and other matters that were not to be divulged to anybody. In fact, this court had said that. I have not made a court order on whether this jury is going to be sequestered. Both parties were asked what their feelings were on that, and the court made it clear that anything that was said back in chambers was not to be released.
That's correct.
And within minutes, it was.
And on behalf of Mr. West, that was a mistake. I will tell you that had I been asked what I was about to say, had I been asked 6 months ago, 3 months ago, 3 weeks ago, or today, should this jury be sequestered, as Mr. Delariando would say the same, yes, it should be. I understand that the court did not make an affirmative decision yet, and that's in the...
Here in court, you said I did.
My understanding was that we had agreement from this side that there should be a sequestration.
You said the court said. I did not. I said I would consider it. I asked you what your feelings were on the matter. Okay, let's move on to the gag order issue.
Okay. Have you had a chance to look at the exhibits that were presented by the state?
Yes, I did.
Okay. Then do you need an explanation as to me suggesting that I thought that the voice would be easy to identify and it's not? Do you consider that an improper inquiry or an improper statement? Because my review of that very video that was presented by the state was that it was particularly and intentionally innocuous. When I said I really thought it would be easy to identify and it's not going to be, we have experts all across the board.
The voice in the YouTube that
No,
is in the state's motion?
No, the non...
That's not what I'm talking about. I'm talking about their third motion for gag order. That's
Third
where
motion
we
for
are
gag
right now.
order. It had on it the YouTube.
And in their third motion for gag order, the reasons for doing it were the YouTube.
That's correct.
Okay.
And I asked you whether or not you had an opportunity to review the YouTube. You said you did.
One of them I could not bring up.
Okay. I'm not sure which one that I should comment on.
The first one about...
Mr. West?
The one that I was able to bring up was that it's the last dot in paragraph 2. The one before that, I was not able to bring that up.
Yes, Your Honor. I might just have a moment.
I don't know what the difference in them are.
I just want to make sure that I'm responding to the right one.
This would be in the state's motion, page 2, paragraph 2.
I'm sorry if I could just have a moment, Your Honor.
Yes, you may.
Well, let me then just respond.
What it says before the YouTube site, it says, on April 30th, 2013, Defense Counsel commented about potential evidence to HLN and references the YouTube site. That is the one I was not able to bring up.
Okay. Then the one that you were able to bring up was somebody commenting about Defense Counsel has said that
In-camera hearing.
the jury would be sequestered or that it might be sequestered, whatever they
Defense
said.
Counsel commented to HLN about a matter discussed during the in-camera hearing that was supposed to remain confidential until the court determined it should be disclosed.
That's correct.
With the YouTube site. That's the one I listened
Okay.
to.
And as to that, I mentioned just now, Mr. West may want to address the court specifically on that in a moment, but let me, if I might, finish simply on a review of what it is that we are or not supposed to do as litigants or as attorneys in this matter. And I don't want to regurgitate everything that was talked to you about during the first and second motions for gag order, but the Gentile case has particular reference. The cases cited by the state once again predate the Gentile case, and the Gentile case, as interpreted by later cases in the state, but certainly the case itself, gives quite specific reference as to what defense attorneys are allowed to comment on, what all attorneys are allowed to comment on. What it doesn't address, because it wasn't relevant in the Gentile facts, was the onslaught of information coming not from the state, but from others that have impact on the case. And I mentioned a couple of those a moment ago to you, about tweets that were done last night and Facebooks that were done 2 weeks ago and comments made about the significance of the case. What Gentile says is that it truly is, one, supposed to be a level playing field, and that information, particularly in a socially significant matter, they actually use the terms of political natured cases. You'll remember the Gentile case, it talked about corruption, and Mr. Gentile, the attorney, was speaking on his client's behalf and responding to them attacking him for having exposed corruption and whatnot. And they said in those, particularly in those cases, and I could cite you to the particular quote, but I know that I've done it before.
I'm very familiar with all those cases, having gone through a motion for gag order in this case previously. Okay.
Then I think your ruling last time as to the reason that a gag order should not be indicated at that point would sustain now. My only concern is that if, in fact, because of some frustration you have with Mr. West and his behavior in talking about what you believe to be, and
I
we
don't
agree.
have any frustrations.
Okay, because I'm not certain whether.
I will remind both sides of the rules regulating the Florida bar, and as I have done so throughout the case. Those are the rules that all attorneys who appear in courts in the state of Florida are to be familiar with and abide by.
Absolutely.
And I don't mean to cut you off on yours, and I'm not going to cut off Mr. Ponce, but I am very aware of all the rulings. I understand the state's reason for bringing this motion, but unless somebody wants to perfect the record with any of their case law, I am going to deny the motion for the gag order. Does anybody want to put forth anything to protect their record? I will allow you to do so.
It was a long, long time ago that Judge Dickey just told me to hush up if you're winning. So,
I guess it could be interpreted that way. All right. Then we have the defense motion to continue.
And this, unfortunately, is a work in progress, Your Honor. I had listed for you a couple of the reasons, and one of which, I've been before you many times on discovery issues, and those just continue. The reasons in the motion that I listed were specific to two. The one that we just began the inquiry on concerning the information that the state had in its possession and for at least 3 months did not forward to me. I don't have that fully vetted out, but it looks as though when we get the rest of the testimony that might be compelling evidence. And not only for the evidence itself, but at a certain point, and I know the court is getting tired of hearing me on this. I'm getting tired of saying it, quite honestly, that there is an enormous amount of information that seems to be very difficult for me to extricate from the state attorney's office in order to properly get ready for this hearing. And now that I keep finding more evidence that I'm not getting what I'm supposed to be getting, I'm going to request an inquiry not only as that which was begun by Mr. White, but a complete review of all the discovery in this matter that has or has not gotten to us, because this case is not going to be tried fairly if I still have to try to get and fight and find out by the incidence of a phone call that there were reports hidden from me. That was out of the blue. I can't even take credit for the fact that I found out information that reports are being hidden from me, but for the conscience of somebody thinking I should know about it, I still wouldn't know that they had it.
Well, that's the
So,
reason why the court has Richardson hearings, and that's why we're going to hear that matter on either June 6th or 7th.
the concern, of course, with Richardson is that, as you know, procedural prejudice sort of suggests that if I find out ahead of time and can scurry about not sleeping and then get ready for trial, that maybe we can still get ready for trial. My fear is that matters will come up in the trial that I'm not ready for, that were not given to me properly by the state. So that's one.
And that happens.
And maybe we can address that more fully and this more fully on the 6th and 7th when we look into that inquiry. The other reason may also be preempted come the 6th and 7th of June, because the other issue is with Dr. Reich, or Miss Dr. Reich. And that is that we got that information. He still, as we took his deposition last Friday, he hasn't completed his report, and he said that he's not going to complete that report for another 2 weeks. I asked him why, and he said because even though he was retained in June of 2012 and forwarded a report to the state attorney's office in June of 2012, a report that he prepared for the Washington Post. We asked him for that at the deposition, and he said he couldn't give it to us last Friday because of his words, not mine, some journalistic thing, some journalistic contract. So we still don't have that. And his report isn't going to be done for the 2 weeks. And when Mr. West asked him why, he said, another quote, I'm a slow worker. I say it may be preempted because you may decide at the Friday hearing that this information, some, all, both sides, one side, whatever, may not come in, which would then mute Dr. Reich or Mr. Reich's failure to get us the information in time. And honestly, the state's still waiting for some of ours. We're all rushing around here. My concern is that in trying to try this case in 2 weeks and 3 days, 4 days, whatever it is, with the discovery done and with the financial constraints that we're under, people like Tom Owen, who wants $3,300 to talk to us, we don't have it. We can't get this accomplished in this time. So though we have made very reasonable efforts, in my opinion, enormous efforts to keep moving forward to get this trial ready for trial on June 10th, that we're not going to be ready and that we're going to need a several week, a couple of month delay to make sure that the experts are lined up, ready to go, witnesses are lined up, all discovery is done, the inquiry of Mr. White is completed, and wherever that leads us, and quite honestly, an additional inquiry as to all the other discovery concerns that still don't believe were fully and finally resolved.
Okay, thank you. Who's arguing on behalf of the state?
I am, Your Honor. As Mr. O'Mara has conceded, their expert still has either A, not done reports, or reports have not been tendered, but we're waiting and we're willing to depose them next week. I think we're set for deposing them. We're starting to depose them tomorrow, Thursday, and Friday. That is, Mr. Manti will be on behalf of the state of Florida. So at this time, we would object to a continuance. This case is dragged on long enough, and I don't want to belabor the point in terms of when discovery was started or when depositions were started, et cetera.
Okay, thank you. Anything further?
No.
I know I've said this before, but I'm going to reiterate it and say it again. On October 26, 2012, the court asked the parties when you would be ready for trial. I was told June. I set the trial for June 10th, 2013 and issued a scheduling order. In that order, the date of that order was October 29th, 2012. The scheduling order set forth the deadlines for disclosure of witnesses, which included expert witnesses, and that was March 27th, 2013. The state disclosed the subject expert to the defense on March 27th, 2013, which was a timely manner for the original schedule. On March 25th, the defense filed a motion for extension of time to file witness disclosure, stating in paragraph 3 and 4, quote, that subsequent to the entry of the court's scheduling order, the defendant has announced that it will not have a pretrial immunity hearing. As such, the timeline for disclosure of witnesses could be extended without having to extend the trial date. Further stated, in view of these facts, the defense requests the court to extend the time for the state and the defense to disclose witnesses to April 10th, 2013, with a reciprocal of April 17th. It's been some 59 days after being informed that the state intends to call this subject expert witness, And the defense files on May 23rd a motion to continue for, among other things, the need to identify whether or not the expert has the background experience and abilities to undertake the evaluation. And it would also require the defense counsel to find, consult with, and hire an additional expert. The court has provided both sides a lot of hearing time. And just to reiterate that, December 11th, I provided whole days for hearing time, the first of which was December 11th. Only the morning was used. January 8th was canceled because it was not needed. February 5th, only the morning was used. March 5th, only the morning was used. April 30th, the morning was used for a hearing. There was approximately 1 hour after lunch that was used for the chamber's scheduling issues. And today's hearing. The court has now offered May 31st, 2013, and June 6th and 7th. I think that's sufficient time to get all the issues done and heard. The motion to continue is denied.
No, before you make that final decision,
I made the final decision.
May I just put something on the record for our purposes?
Yes, you may.
Thank you. And again, I understand the court's ruling, but I just have to remind you that on our hearing in October, your last date that you had available for discussion of trial was June 2013. We told you we could not tell you when we were going to be ready because it was well too early, but since that was the last page that you had in your calendar, we picked June. So I understand, but we did not tell you that we would be ready in June when we had the hearing in October. However, I understand we certainly have been trying to do that. I do want to make sure you're aware that on March 27th of 2013, the state filed their witness list with Hornsberger and Horleen and Reich as Category B witnesses, Category B. On April 12th, we received an illegible copy of Dr. Horleen's report. We sent an email requesting it, and 3 days later got a legible copy, and then we had the deposition, and we asked for the foundational data for Horleen's report, because that's what our experts would have to look at. And on April 21st, we followed up with an email. We first wrote the letter on that day, on the 19th, followed up with an email on the 21st. On the 27th, we followed up with another email. On May 3rd, we followed up with another email. On May 10th, we followed up with another email. And on May 16th, we followed up with yet another email. And on May 21st, we followed with yet another email. We still haven't gotten that. Now, on May 10th, we received a copy of Alan Reich's letter without the 5 attachments. And on May 14th, we asked for Alan Reich's files via email. On May 22nd, we received Tom Owen's files, May 22nd, last week. May 24th, we took the deposition of Alan Reich where we found out that he would need the additional 2 weeks and will still not be completed with his report. So while I understand the court's frustration that you think that we said we could be ready in October to try this case in June, if I indicated that to you at all, it was an indication based upon a premise that we would actually get the discovery the way we were supposed to get it.
That was just my starting point. I will remind you of your March 25th, 2013 motion that you filed. You said the timeline for disclosure of witnesses could be extended without having to extend the trial date.
Agreed.
Those were your words.
Right, that was back then.
The motion to continue is denied. There were several motions that were filed here, and I put them together, and I know I went out of different orders of the notices of hearing. Did I address each one of those motions?
Can you give me a moment, Your Honor, we
Yes.
can check? I tell you what, would it be easier if I just list them real quickly, and I think that'll document it? Regarding Shelley Zimmerman, we addressed. Hearsay statements of the defendant, we addressed. Appropriate penalty, we addressed. Prior criminal history, we addressed. Regarding Trayvon Martin, addressed. Regarding calling of witnesses, addressed. Opinion evidence, addressed. Motion to eliminate it. Regarding toxicology, addressed. Order requiring discovery obligations, addressed. Gag order, addressed. And CVSA, addressed. And then I just want to confirm that all of those listed on our second amended notice of hearing. Evidentiary hearing regarding admissibility of expert testimony, addressed. Allowing jury to inspect, addressed. Anonymous jury, addressed. Allowing additional witness evidence disclosure, addressed. And allowing expert testimony, addressed. Reasonable fee, addressed. sanctions addressed and motion to continue addressed. That's all I had on both motions.
Okay, did the state have any motions that I had not addressed?
We agree that the court has addressed all motions. If I may inquire of the court, I don't know if the court was through in terms of both sides meeting with the court regarding just scheduling of jurors and security issues at all.
No, I'm not going to have that meeting. What I will say, though, is if you all still want to provide the court with your suggested jury questionnaires, if you'll provide them to me, I will review them. As I had indicated that I have drafted some jury questions, so I will consider whatever ones that you have. If you want to give them to me on June 6th, that's fine.
May we now get a copy of yours so that we can review that in context of ours?
No.
Will we have addressed that in a hearing at some point, or how will we?
You'll have them the Monday morning before they're given to the jurors.
You're talking about then June 3rd?
June 10th.
Oh, the Monday morning they're given to the
Yes.
jurors, okay. Are we, oh, Your Honor, I'm just curious, does that mean that you are, I'm not certain what you anticipate. Are you going to then incorporate potentially some of our questions in?
I will take the questions, but both of you will provide to the court. If you can exchange them with each other, and I will consider whatever objections you have about the other person's, the other side's questions, and I will make a determination as to what, if any, questionnaire will be provided to the potential jurors.
If I may, Your Honor, I provided it already to the defense counsel. If I may just, and we have a couple of these questionnaires to state.
Thank you. I will keep that in
Let me,
mind.
it sounds as though you've made this decision, but let me specifically request a hearing before the Monday that is going to be given to the jury so that we can vet through questions that we believe are necessary to have on the questionnaire as well. The state may have some as well.
I think that the, whether or not and how to select a jury is really discretion of the court. Unless you could show me case law that says I'm required to give a questionnaire, I'm going to do it my procedure.
I understand that. It is in your discretion, Your Honor. Just hopefully it might take some insight or suggestion from us on a case with our involvement. And if I might, I do have a proposed confidential jury questionnaire as well.
Have you both exchanged them and know whether or not the other side, thank you, has any objections or?
We've exchanged them. We haven't talked much about them, but we certainly will.
Okay, if you'll go ahead and do that and let me know, I will take them into consideration. Yes, Mr. West? You're standing up, I thought you wanted to.
No, I was a part of the discussion about the questionnaire and how that would evolve. So echoing what Mr. O'Mara said, yes, we just got Mr. Villarreal's and we provided him with ours, but we've not compared because we thought we were going to have a hearing where we would discuss the questionnaire and arrive at a questionnaire. So I understand the court's changed that procedure now, so we will try to meet with the state and see if we can reach some agreement.
All right, and you can let me know. So the next time we're meeting, I'm looking through my notes, is on the morning, 9 a.m. June 6th, and if we need to go into June 7th, we will do that. Council will let me know regarding the motion for sanctions as to whether or not Mr. White's going to be here on the 6th or the 7th. So those are the only two issues that we still have hearing for, correct?
Judge, I believe we scheduled this Friday at 1:30 regarding the photographing of the jurors. Mr. Ponce.
Mr. Ponce's motion.
And Your Honor, as to the Fry hearing with the telephonic testimony, is it Your Honor's intention to conduct it by speakerphone here in the courtroom, or should we?
Well, I'm sorry, I
I
didn't
just
hear.
need to have the witness, I need to know when to have the witnesses available.
I'm going to start court at 9 o'clock. You could gauge how long that's going to be. If both sides will have whatever witnesses appearing by telephone be in the presence of a notary who can take their identification and swear them in.
Yes, Your Honor, thank you.
Okay, I don't know how many witnesses that you all are going to call. Mr. Ponce, are you available for May 31st at 1:30?
Yes, ma'am, and we will submit briefing about the issue, and the briefing may indicate that we're not going to appear. Is if the order gets entered under the rubric it's supposed to be entered in, and not under pursuant to standing policy, that may be okay for us. As a policy issue, our clients may not want to publish photographs of the jurors.
So you'll let me know?
I will.
And you'll let the parties know?
Yes, ma'am.
And on behalf of Atlanta, so we'll let you know, Your Honor, too. It's my understanding that you took the remainder of the anonymous jury motion under advisement. Is that correct?
Yes.
Would it be possible for us to file a brief on that in response to that?
If you want to, yes.
Okay, just to provide some case law since we didn't have it beforehand. Thank you, Your
Okay.
Honor.
So just for everybody knows, what we're doing is on Friday, May 31st at 1:30 PM in this courtroom, we'll be discussing the portion of the anonymous jury that concerns the photographing of the jurors. And then on June 6th, and if it runs into June 7th, we'll have the Fry hearing and also continue the hearing on the defense motion for sanctions. Is there anything else that anybody needs any help with, or I can do prior to May 31st?
No, Your Honor.
Defense?
No chance we can discuss the questionnaire issues when we're here on the 31st?
Well, I never said there's no chance for everything, but as I sit here for today, that answer is no.
Yes, Your Honor.
Okay, thank you all very much. Court will be in recess. Thank you.
You can just email it to me. Yeah, you should have it. And when I get back to the office, I'll send you a quick little binder. Yeah, that would be great.
You guys still want to do the demo where I'm in to try to set something up?
Are they ready to do it right now?
He said he could have the clerk stay and call them up if you want to do it this afternoon. It's up to you guys, right? Because you guys are obviously very...
Make sure we know how to do this.
Electronics demo.
Yeah, we'll see what we get about that.
Yeah, so this would be like for video testimony?
Yeah.
Sure.
That'd
You
be
guys
great.
want to stick around to do electronics demo?
Oh, yeah, you guys do the great. Is that all right?
Yeah.
Will we be able to try some of this out?
Could be anything, but I just,
No, there
before
was
we
no-
pre-mark
well,
things, I
we
want to
just
make
come up
sure.
with a list of what we want, and it's really not much different. You sent it to Mark at Mark O'Mara, right? Probably.
Yeah. I've only got one address for you.
I have that. Okay.
The questionnaire you had there, the same one you gave us?
Yeah.
Okay. I guess we can discuss it at some point.
Yeah, it's not. What's going on? What should you do? I mean, I reamed him out more than she would have. Got it.
Bernie, bye. Congratulations on your daughter's wedding.
Ladies and gentlemen, if you could clear the floor, please.
Bye, Mark.
How about your, I'm gonna get to it. You complain about it. And then you sit here, you know, and I'm. Say, I'll get back to you. With all due respect, you're being unfair, all right?
You deserve all the evidence.
All right, you chastise me, you get. You got the whole thing.
Tell us, it's up,
You got the whole thing there. I mean, you have the whole,
I don't know.
whatever.
I just want to try the case. I really just want to try the case.
You text me and told me you would have reports from these people.
We don't have any.
They're not gonna do any reports.
They're going to, I'm really talking to you, it's going to get this done right away. I really think that's going to be done very soon.
You guys want to hook up the laptop? Yeah, I did. Okay, do you have any audio? If you do, this goes into your headset.
Yeah, we can try it just for this heck of it. But I did have some, I just wanted to, get an.
It's on?
Yeah, get an idea of the lighting. Yes.
And maybe the I think it's likely that they were sent, I'm not, but they didn't do any lab work.
I guess I need to do about use of Western.
Is telephone.
That's when we keep publicizing all the negative evidence.
He sees not too big a deal.
You know, don't tell me that I'm good at also.
Are we going? Okay.
I must begin by saying that without our parents' unwavering support and without our sister Grace's many sacrifices that have weighed heavily on her, I would simply lack the courage to engage and endure the toughest fight of my life, the fight to save our George. The moral support we have received from our parents is incalculable. Mark O'Mara and Don West have gone out of their way to be attentive to our concerns, to reassure us, and to help us better understand and navigate our way through a myriad of challenges we were unprepared to face. We owe Mr. O'Mara and Mr. West a debt far greater than either of them would ever admit, and far greater than any of us would ever be able to repay. The standard of care which they have applied in dealing with this case and with our family is second to none. When I decided to engage the public, I knew the job would come with a great risk to me and to my family. Our family's private life would be scrutinized, and every detail would be combed over by the press, just as the press had done to George. I did not, however, expect the viciousness I would encounter for simply telling the truth. As the children of two public servants who always taught us by example to serve our communities with honor and wisdom, the question for me evolved from an uncertain what should I do to, more importantly, what can I do? What must I do? Our parents ran a home where truth was the core value and the foundation for all other virtues. Faced with seemingly insurmountable adversity, I gathered every ounce of resolve, and relying very heavily on moral strength, made it my mission to tell the truth, fearlessly and consistently. Almost at once I was dubbed a liar. The truth was described as inconceivable, insane, ludicrous, to name a few choice words. The attacks continued. Don't listen to him, he's George's brother. Don't listen to him, he's making things up. Later and most viciously of all, don't listen to a thing Zimmerman Jr. says, he's gay. 13 years ago, in a very different time, I struggled with one of the most difficult decisions a young man could face. How could I reconcile being truthful with concealing the reality of my identity? Didn't being honest start with being true to oneself? I came out to my family in the era of rampant bullying, in spite of our religion and on the heels of the Matthew Shepard tragedy. My family and friends struggled to understand what this meant. My world felt like it was spiraling out of control. I thought I had lost love, lost acceptance, lost the approval of the people that I love the most. When I was living the darkest days of my life, and for the first time living without my family, for telling the truth, George was the first one to come to my new home, the first to embrace me, the first to assure me everything would be right again, because I was telling the truth. Maybe not today, maybe not tomorrow, but it would get better. George was right. He became my staunchest advocate. As it turns out, we now know George was the first person to greet new neighbors when they moved into the neighborhood. George denounced the Sanford Police Department's actions in the Sherman Ware case for what he viewed as a police cover-up when he first learned of it. George was the man who put the welfare of underprivileged children first by continuing to mentor African American children, even when the county withdrew funding from the mentoring program. Weeks before the incident on February 26, he was the first of our grandmother's grandchildren to arrive at the hospital where she was admitted, staying by her side, sleeping on the floor if necessary, to care for her. Soon after, my father had a heart attack, and George was not only the first one of us to tend to him in the hospital, but also facilitated my arrival in Florida and arranged transportation for me so that I'd be able to help my family cope. George lived in a community plagued by crime, and it turns out he was the first one to reach out to police to try to help his neighbors. George is a good, decent, and honest man. It is now my honor to advocate for him. George is in the fight for his life quite literally. As the oldest son, the only right thing for me to do is everything I can do to deliver him back to our parents. The only right way to do it is by relying on truth. We are not a wealthy family, but we are rich in honor. We are not a large family, but we make up for our small numbers with courage. Despite our limited resources and our very bizarre and challenging situation, we have been joined by many men and women who believe in the rule of law. Each of them in their own way has contributed to the quest for truth and has done what they can to help. We are grateful to all the voices across our land who continue to speak up and the many who continue to stay vigilant. I assure you, as our mother assured you, your trust in George is well placed. I want to thank them all for their unwavering support. It is on their behalf that I speak out today. I've heard you all. I've been listening for a very long time now. In a word, you are disgusted. Quite simply, the media acted with sheer incompetence and the American people were misled. With reckless disregard for the safety of the public, the media accepted as fact and promoted as truth a false narrative presented by attorneys who have a now proven financial interest in repeating a racially inflammatory falsehood. We are now faced with an aberration of justice. Statute which is supposed to protect those who are forced to protect their life has been defiled. The media's incompetence laid the foundation for the misled public to demand an unfounded charge, and an innocent man is now faced with an improper charge. It is to give voice to all of you, the otherwise voiceless, not as a spokesman for the defense, nor as a family representative, that I am calling on the state of Florida to do the right thing, the only just thing, what should have been done long ago. I believe the time has come to withdraw the charge of murder in the second degree. The men and women of the Sanford Police Department, sworn to uphold the law, were doing their job when they refused to charge someone with a crime who had committed no crime. The men and women of the state attorney's office who swore to uphold the law were doing their job as well. In this country, you don't charge someone with any crime solely to assuage the concerns of misinformed masses. The people of Sanford, Florida, and Americans in general deserve to hear the right message on April 11, 2012. George had committed no crime, and charges would be unwarranted. George was viciously blindsided by a nose-breaking attack and then pinned to the ground by an experienced fighter who continuously and relentlessly attacked him. George was ultimately forced to defend himself. They deserve to hear that the law had worked, that the people in the police department and state attorney's office charged with protecting them were men and women of integrity who had followed the law and honored their oath. They deserve to know the evidence, when objectively examined, spoke for itself in regards to George's innocence. Instead, that day, the politics of race trumped the rule of law, and a political calculation was made. It was the wrong decision. It is now high time, in the name of justice, to withdraw this improper charge. Thank you.